Right now, while you're watching this, the savings account you opened in your own name is doing exactly the opposite of what the wealthiest families in America have been doing for over 100 years. I want to say that plainly. The piece of paper you signed at the teller window in 1972, or the online form you clicked through in 2014, sets you on a path that the Phipps family, the Pitcairn family, the Whitney family, and the bank that J.P. Morgan built on Madison Avenue would never put a dollar of their own money inside. They use a different structure. It has been sitting there on the books in plain English since July of 1907. I am not a tax attorney, and nothing I say here is legal advice for your situation. I have spent the better part of the last year reading family office filings and trust company charters, and I want to walk you through what I found. Stay with me, because the part most people miss is the one that sits at the very end. To understand the structure, you have to go back to the morning of July 17th, 1907. A man named Henry Phipps Jr. walked into a small office in Hoboken, New Jersey, and signed the papers that founded a private trust company. He called it Bessemer Trust, after the Bessemer steel-making process that had made his fortune. Phipps was the longtime business partner of Andrew Carnegie. The year before, in 1906, he had sold his stake in Carnegie Steel to a syndicate organized by J.P. Morgan for roughly $50 million in 1906 money. That figure, in today's dollars, lands somewhere north of $1.5 billion. Phipps did not deposit it. He did not put it in National City Bank or in any of the trust departments along Fifth Avenue. He moved it in a single coordinated set of transfers into the trust company he had just formed for his children. 3 months later, the panic of 1907 swept the country. Knickerbocker Trust collapsed on October 22nd. Depositors lined up around the block at 24 banks across Manhattan. Phipps's money did not move. It was not in a bank. That same year, John Pierpont Morgan was running his private bank out of the building at 23 Wall Street. The marble lobby, the iron doors, the men in dark suits. Morgan's bank was not a savings bank either. It was a partnership that held assets for a small list of families. Down the street, Brown Brothers Harriman traced its origins back to 1818, when Alexander Brown arrived in Baltimore from Belfast. In 1931, in the middle of the worst banking crisis the country had ever seen, Brown Brothers merged with Harriman Brothers and Company to form Brown Brothers Harriman, the partnership that still operates today. The Whitney family had its own office on Fifth Avenue. The Rockefellers built theirs at 30 Rockefeller Plaza. The Rothschilds on the Rue Lafitte in Paris, and later at 8 Place de la Concorde, ran a similar arrangement going back to the early 19th century. None of these were savings accounts. I want you to feel the contrast. The Federal Deposit Insurance Corporation did not exist until 1933. Before that, every dollar a regular person put in a bank could disappear when the bank failed. Between 1929 and 1933, roughly 4,000 American banks failed. Depositors lost their savings in waves. But the Phipps family, the Pitcairn family, who founded Pitcairn Trust in 1923 with the proceeds of the Pittsburgh Plate Glass Company. The Whitneys, the Rockefellers, none of them lost their core capital. Why? Because they were not depositors. They were owners of trust companies that held their own assets. The bank that profits from your deposit, the financial advisor whose annual commission depends on you holding a particular fund, the savings product that pays you 4% while the bank lends your dollars out at 9%, none of that touches a family office. The structure was designed from the first morning to remove the middleman. I want to name the structure clearly. It is called a family office, and the formal legal vehicle inside it is most often a private trust company. Bessemer Trust, founded in 1907. Pitcairns Trust, founded in 1923. Both still operating. Both still controlled by the descendants of the founders. The private trust company is chartered by a state. South Dakota and New Hampshire have specific statutes for private trust companies that allow a single family to charter its own. Wyoming and Nevada have similar provisions. The trust company is not a bank. It does not take deposits from the public. It does not need FDIC coverage because it is not a depository institution. Instead, it holds assets in fiduciary capacity for the family that owns it. And it can be paid a fee for that service, which under the right facts and circumstances becomes a deductible trade or business expense. Here is where the tax law matters, and I am going to be careful with the language. Section 162 of the Internal Revenue Code allows a deduction for ordinary and necessary expenses paid in carrying on a trade or business. Before 2018, a separate provision, Section 212, allowed an investment expense deduction for individuals. The Tax Cuts and Jobs Act of 2017 suspended Section 212 miscellaneous itemized deductions through 2025. That sounds like bad news for wealthy families. It was not. There's a line of cases, the most important of which is Lender Management L, LC versus Commissioner, decided by the Tax Court on December 13th, 2017, TC Memo 2017-246. The court held that a properly structured family office can qualify as a trade or business under Section 162 if it is providing services to multiple separate clients, even when those clients are family-related trusts and entities. That ruling meant the family office deduction survived TCJA when Section 212 did not. The structure became more valuable, not less, after 2018, because the families who could afford the legal work to qualify under lender kept their deductions while everyone else lost theirs. Let me show you the contrast in concrete terms. The FDIC-insured savings account at your local branch carries a coverage cap of $250,000 per depositor, per insured bank, per ownership category. Anything above that sits exposed if the bank fails. The interest the account pays is taxed at ordinary income rates, which for a household in the upper brackets runs from 22 to 37% at the federal level alone. When you die, the account goes through probate in your state, which is a public proceeding that takes anywhere from 9 months to 3 years and costs your estate between 3 and 7% in fees in most states. The account is reachable by creditors and by anyone holding a judgment against you. Now compare that to the private trust company holding assets for a family. There is no FDIC cap because the assets are not deposits. The assets inside can be placed in tax-deferred or tax-exempt vehicles. Private placement life insurance, governed by Section 7702 of the Internal Revenue Code, allows assets inside the policy to grow without current income taxation and pass income tax-free at death. Municipal bonds, governed by Section 103, pay interest that is exempt from federal income tax and often from state tax as well. Direct private equity holdings are taxed only on sale, with the capital gains rate capping at 20% at the federal level, often with substantial deferral. The structure is creditor protected if drafted properly under state law. It does not go through probate at the death of any single family member because the trust holds the assets, not the individual. Let me walk the mechanism step by step. First, the family forms a state-chartered private trust company in South Dakota, New Hampshire, Wyoming, or Nevada, depending on which state's law best fits the family's goals. Second, the trust company is owned, usually by a holding entity that itself is owned by family members or by trusts for their benefit. Third, the family transfers its investable assets to a series of trusts, of which the private trust company is the trustee. Fourth, within those trusts, the assets are allocated across vehicles. Private placement life insurance for a portion of the liquid wealth, sheltered under Section 7702. Municipal bond ladders for tax-exempt income under Section 103. Direct private equity stakes for long-term growth and deferred capital gains. Real estate held through limited partnerships for depreciation and step-up basis at death. Fifth, distributions to family members are made through grantor trust mechanics, governed by Sections 671 through 679, which let the family shift income tax burden in ways that an individual savings account cannot. Sixth, the family office itself, structured under the lender holding, charges fees that are deductible to the entities it serves. Each piece is on the books. Each piece is in the code. None of it is hidden. There's a catch, and I want to be honest about it. A true single-family office, with its own private trust company and dedicated staff, typically requires a minimum threshold of about $30 million in investable assets. The annual cost runs between $100,000 and $500,000, depending on staffing and complexity. Below that level, the legal and accounting overhead eats the benefit. For families with 5 to 30 million, the multifamily office model, where one trust company serves several unrelated families, brings the cost down. Titamine Advisors, Pathstone, Crescent, and others operate in that space. Below 5 million, the family office structure proper is generally not economic, but several of its components remain accessible. I want to tell you the story of how Bessemer Trust survived the 20th century, because the story is the point. July 17, 1907. Henry Phipps Jr., age 68, signed the founding charter at a small desk in Hoboken. He had sold his Carnegie steel stake the year before for what most sources record as roughly $50 million, with some accounts placing his personal proceeds at closer to $40 million. He had grown up in a row house in Allegheny City, Pennsylvania. He had worked as a $15 a month accounting clerk for an iron firm in 1855. He had partnered with Andrew Carnegie in 1861 and stayed with him for 45 years. When the sale to J.P. Morgan Syndicate closed, Phipps did not retire to a yacht. He spent 6 months with his attorneys drafting the trust company instrument. He named his 5 children as the original beneficiaries. He kept majority voting control until his death in 1930 at the age of 91. October 22, 1907. Knickerbocker Trust, the third largest trust company in New York, collapsed. Depositors lined up at 24 other banks. The Panic of 1907 wiped out an estimated 40% of stock market value before J.P. Morgan personally organized a private bailout. Bessemer Trust was untouched. The capital was not deposited anywhere. It was held by the trust company, which Phipps owned. In 1916, the federal estate tax was enacted, with rates that would eventually climb to 77% on large estates. The Bessemer structure, with assets held in trust rather than in individual names, was already positioned to use the lifetime exemption and the marital deduction in ways that minimized estate exposure at each generational transfer. In 1929, the stock market crashed. Between 1929 and 1933, 4,000 American banks failed. Depositors at those banks lost an estimated $1.5 billion in 1933 money. Bessemer Trust survived because it was not a bank. It held its family's assets. It did not owe demand obligations to outside depositors who could run. In 1933, Franklin Roosevelt declared a 4-day bank holiday and signed the Glass-Steagall Act, which created the Federal Deposit Insurance Corporation. The FDIC began insuring deposits at participating banks up to $2,500 per depositor on January 1st, 1934. Bessemer Trust was not in the FDIC system because it did not take deposits. World War II came and went. The federal estate tax was raised. The income tax expanded. Bessemer Trust adapted. The 1986 Tax Reform Act stripped many shelters from the code, but left intact the trust company structure, the grantor trust rules, and the muni bond exemption. The 2008 financial crisis brought down Lehman Brothers, Bear Stearns, Washington Mutual, and dozens of smaller banks. Bessemer Trust kept operating. The 2017 the Tax Cuts and Jobs Act removed Section 212 miscellaneous deductions, but the lender ruling, decided the same year, preserved the trade or business deduction for properly structured family offices. Each inflection point, the structure passed through. Today, Bessemer Trust manages over $100 billion in assets for approximately 2,700 families. The Phipps descendants still control it. The original 5 children of Henry Phipps Jr. became roughly 300 living descendants spread across multiple generations. The structure that survived 1907 is the structure that is still managing their wealth in 2026. Now, let me come back to the savings account. The reason I am telling you all of this is because the savings account, the certificate of deposit, the checking account in your name, was never designed for wealth preservation. It was designed for short-term liquidity for the working family. Look at what happens. Inflation, by the official Consumer Price Index, has averaged about 3.5% annually since 1965. That means $1 in 1965 buys what about 14 cents bought back then. Or put the other way, $1 in 1965 has the purchasing power of about $9.10 in 2026 money. If your grandfather opened a savings account at First National Bank of Cleveland on January 3rd, 1965, deposited $250, and that account compounded at the average savings rate over the next 6 decades, his deposit would have grown to perhaps $1,800 by 2026. That number sounds like growth. It is not. In real purchasing power, $1,226 is worth about $195,1965. He gave the bank $250 of 1965 purchasing power. He got back $195 of 1965 purchasing power. The bank, in the meantime, lent his money out at 8%, then at 12% during the 1980s, then at 5% in the early 2000s. The bank's spread bought a branch in another county. It paid the salary of the regional manager who never knew your grandfather's name. Your inheritance, in 1965 terms, bought your father a used radio. The FDIC cap at $250,000 per depositor protects only that amount. Anything above sits exposed. The interest the account pays is taxed at ordinary income rates every year, whether you take the money or not. The account passes through probate at death, a public proceeding that costs the estate 3 to 7% in most states and takes the better part of a year. Creditors can reach the account. A judgment in a slip and fall case can attach to it. A divorce can divide it. None of those things touch a properly structured trust holding. None of them touch Bessemer in 1929. None of them touched it in 2008. The savings account fails on 4 counts. Inflation eats the real value. The FDIC cap leaves anything above $250,000 exposed. The interest is taxed at the highest ordinary rates. The account passes through probate. The structure that the Phipps family signed onto in 1907 fails on none of those counts. I am not your attorney. I want to say that again. What follows is a description of structures that exist, not personalized advice. There are several pieces of the family office model that are accessible to households well below the $30 million threshold, and I want to walk you through them in order of asset level. First, multi-bank deposit insurance. IntraFi runs 2 services, CDARS for certificates of deposit and ICS for money market accounts, that spread your funds across member banks so that the FDIC coverage stacks. With IntraFi, you can get FDIC coverage on amounts up to roughly $50 million by holding a single relationship at one member bank while the money is parceled out behind the scenes. Second, federally tax-exempt municipal bond funds. The interest on most state and local government bonds is exempt from federal income tax under Section 103 of the Code, and often exempt from state tax if you hold bonds issued by your home state. Third, Treasury Direct accounts. You can hold Treasury bills, notes, and bonds directly with the U.S. Treasury without going through a broker, which removes counterparty risk and management fees. Fourth, a family limited liability company holding investment assets. A family LLC, organized in a state with favorable LLC law, separates your investment assets from your personal name, provides charging order protection in many states, and centralizes management. The legal setup typically runs $3,000 to $15,000, depending on complexity. Fifth, a multifamily office relationship. Firms like Tiedemann, Pathstone, Crescent, and Bessemer itself offer multifamily office services to households starting at roughly $5 million in investable assets. Sixth, a donor-advised fund for charitable holdings, which gives you an immediate deduction at funding and lets you make grants over time without operating a private foundation. The threshold matters. At $250,000 in investable assets, a family LLC plus a donor-advised fund plus intra-fi deposit insurance covers most of the ground a savings account does, with better tax treatment and creditor protection. At $1 million, you add direct municipal bond holdings and a more structured estate plan with a revocable living trust to avoid probate. At $5 million, the multifamily office relationship becomes economic. At $30 million, the single-family office with its own private trust company becomes economic. The point is, the structure scales down. The principles do not change. The vocabulary you take to an attorney's office is the difference between leaving with a savings account and leaving with a plan. When you sit down with a qualified counsel, ask by structure name. Family LLC, revocable living trust, irrevocable trust, grantor trust, donor advised fund, multifamily office, private placement life insurance, if your asset level supports it. The attorney who hears those words knows you have done your reading. Picture, for a moment, the desk in Hoboken on July 17th, 1907. Henry Phipps Jr., 68 years old, in a dark suit, signing the trust company instrument. 3 months later, the lines around Knickerbocker Trust. 24 banks suspending payments. 40% of stock value gone. The Phipps Capital, untouched. Then picture the kitchen table in Akron, Ohio, in January of 1965. A man named Walter, 52 years old, a tool and die operator at the Goodyear plant, walking to First National Bank with a folded envelope. He deposits $250. He signs the passbook. He goes home and tells his wife the money is safe. The bank lent it out at 8% that same week. Walter's name was not on the loan. Walter's name was on the passbook. The bank built a branch in Cuyahoga Falls with the spread. Walter died in 1991, and the account, by then around $1,400, went through probate over 14 months. His son got $980 after fees. The family in Akron never heard the word Bessemer. Nobody in Akron told them about Section 162 or Section 7702 or about a family LLC. They were not the audience for that conversation. You are. If this is useful to you, write in the comments, in your own words, the sentence, "I want the next attorney meeting." That tells me which households are ready for the next layer. In the next video, I want to walk through the 1903 filing that the Vanderbilt family made on Fifth Avenue real estate, and how that filing shaped the way the next 4 generations of that family held property without paying recurring transfer taxes. The rules they have always used are still on the books. The only question is whether you take the time to learn them.